First, can you hear me okay if I'm right here?
Yes.
Pretty good. A little closer.
Thank you. So, we're not able to start the meeting until the district attorney arrives. He's been delayed, is on his way. So we really can't get going with the formal meeting, but Mark, maybe we could go to managers matters, if we just more way of information, not just voted on.
I would say you wait for the attorneys anyway. Excuse me? I would say that you just wait for the attorneys, and you think you're actually starting the meeting, then. Is that correct?
It would be correct, but the attorney's not meeting for those items, so it's up to the matters board president to decide.
Can you talk a little louder, Mark, or if
We just have to reset a few bullets to kick in.
There's been an hour or something.
Mark, when you reset it, just use the mouse button, is that all you did?
Yeah, that's all I did in the past, yeah.
We're upstairs in the auditorium.
Yeah, they tested the
Well, let's take a poll
I
here.
just want to make sure we're not violating any.
I understand, so I would feel it would be better if we went over to the city chambers in the future, because at least they have a reliable system. This one has battery issues and other technical problems. I mean, anybody have any objection in the future, we just go over to the city chambers?
Yeah, dude, because it's too small.
It is too
It's
small.
too small.
We don't know how many people are going to be here. That's the problem. I mean, we could wait and see and then move over there, or, I mean, that's the thing to be an issue.
Well, everything's working now.
Yeah, there you go.
That's perfect.
Except for this one.
Okay, there is one bad.
He said there is one bad.
Yeah, that's what I thought.
I didn't grab the bad one.
They were working fine this morning. They were working fine this morning.
This is the bad one too. This is the bad one too.
Yeah, probably should. Probably should. Yeah.
Mr. President, if it's okay, I'll just give a quick summary of the engineers matters and the managers matters.
Why don't you start with the manager's matters? I think there will be a discussion on those.
The managers matters, I was able to provide the April.
How are you doing this without a quorum or anything?
Because we're not voting on anything, this is just an informational report. We're going to that, to what would be item
I thought you had to have a quorum to start the meeting. Maybe I'm wrong.
Okay, but these just are not matters that there would be any vote on them, just a manager's report.
I'm not trying to
We can come back to it, later when we have a quorum sworn in, if you want.
I just thought you had to have a quorum before you started the meeting.
Actually, officially, that's why I'm saying you're officially starting the meeting by talking about what's on the agenda. I'm just, I don't know. I know what you're saying. But
I'm not trying to make trouble, Mr. Dillon.
How far out is it? Your attorney?
I'm not really sure right now.
I can call him if you like.
I'm fine as long as they're using the speaker, but, yeah, thank you, Jeff. Yep.
No.
Yes, sir.
Can you hear me now? Oh, look at that. Progress.
Call the meeting to order. Do we have proof of publication?
Yeah, proof of publication is in the office is
Mark, can you use your mic, please?
is the annual publication that we did for all the meetings. There'll be no future advertisements in the paper unless we make a change.
You only have to publish it one time?
Correct.
Whole year?
Correct.
Oh.
Okay. The next order of business is to swear in new supervisor Timothy Dooley.
Before we do that, we have a couple of residents who would like to speak on this issue. We did receive a letter in the mail from some concerned citizens who wanted to speak prior to Mr. Dooley swearing in. So with that regard, I have a speaker, Mark Kopecki.
Yes, thank you. Mr. Bear, I asked you the last meeting if you felt it was legal for a board to change the procedures that had been published in the meeting packet ahead of time, and you declined to answer. Then are you prepared to answer that question now?
I am.
Thank you. If you would, please.
We give all the comments and then I'll go down. Okay, so as you all know, I was here fresh on that first meeting, not yet sworn in. This question was presented to me at that time. And so the question is it possible to change the published rules of the meeting versus whatever? Versus what was there at that time? Well, the answer to that is what is not permitted is to establish a set of rules that is contrary or different than the requirements under the 298 statute. So ultimately, the question that I think is the larger what we're getting at is, was the election at that meeting conducted properly? And from what I've reviewed, that election was conducted properly under the requirements of Statute 298, which governs how your board is elected. So the relevant kind of issue that was out there at the time was, hey, the rules as published on the website said the candidate's got to be there. The rules that were handed out at the meetings said the candidate doesn't need to be there. those rules could not amend the requirements of the 298 for qualification of a board. By example, many of my 298 districts utilize a mail ballot to all of their residents. And the reason they do that to make it as easy for everyone to vote as possible. Under 298, the election needs to occur at the landowners meeting, so the ballots are delivered to that meeting. People can deliver ballots up to the date of that landowners meeting. The tabulation can't occur until then, etc. The requirements under 298 for the board member is to own property in your district. Some 298 districts have their own special charter, additional rules about somebody can reside on this half of the district or that half, etc. There's no additional requirements here. So to the extent that sort of how the meeting's going to be conducted to that one point is that I don't think that would change the outcome, because I don't think we can make additional requirements that are not in your charter and are not in 298 as to how somebody qualifies to reside in your district. So, the purpose of that procedural list is how we're going to conduct the meeting that day. At the end of the day, the requirement under a landowners meeting is you elect a chair from amongst all of the landowners to conduct the meeting, and then that chair conducts the meeting. And that follows that sort of how it's going to be the adoption of the rules. Again, serving as district attorney at the time, my guidance would have been there was going to be a vote on that procedure. That was an informational document of how the chair was going to proceed. However, if somebody was elected from the audience and they conducted it, as long as they conducted the meeting in accordance with those rules of 298 in your charter, there would be nothing to call a rule about it. We would take the procedures and go, we're not doing this, we're all here, we're going to conduct the election, you vote by acre, once those votes are tabulated, as long as that person qualified, they're elected to the board. So that's the very long-winded answer to your question. But at the end of the day, that policy was the guidance of how the meeting was going to be conducted that day. I don't think it changes the outcome of the election or can modify the requirements of how that election is conducted and who can qualify for your district.
So then, to make sure I understand, you don't feel that a district can make the requirements that are set forth in the statute more stringent?
That's right. You can't say, our board has to be 80-year-olds. You couldn't do it.
Thank you.
We had John Savage also wanted to speak on this item.
Okay, first of all, that was a lot of talk, but you really didn't say much.
Thank you.
As an attorney.
First of all, that voting procedure is a voting, it's voting, so it falls into other categories, but to change the one you published on your website, say 3 days, say 3 days ahead of time, but I don't feel that was what it was, but we were never even told there was a change in the voting procedure, and it was a charade to get everybody to vote on it, when we didn't even know that you had changed it. When me and Mark and everybody else that reads these board packs, I have it right here, knows what the voting procedure is. So that's the first problem. That's the first problem. I'll let you say back when you want to, but you can't just change the voting procedure. And Mark Mathis spoke to Paul cannot do it by himself.
Say, John, on this issue?
Yep.
Grant, you want to fill out a form on this
I
item?
didn't put it on there. Thank you. Grant Dan?
Just turn it off.
Grant Dan? Hello? You hear me?
There we go.
All right. Yeah, I concur with John, with he didn't change it, or he didn't notify anyone that he changed it. I've been on many boards, and we always have to notify, and there's a change in anything that's in the board packet, you should make that, you actually have to vote on it and it'll be amended, and it was no discussion. Mark doesn't ever ask anybody, he goes first, I need a motion, I need a second, and then you vote. That's the way he treated it. He never says any discussion on that. In the statute 838.022, it says can't change the official record document except authorized by law or contract or causing another person to perform such an act. It's in their official misconduct. I think I got a copy of it if you want. I can give it to you. It states that it's a felony or to get convicted of that. He misled the public, he deceived the public on that day.
Does anybody agree with
He
that?
agreed,
Yes.
later in the video, the YouTube video, he admits that he did change it that week. So he does admit that he did change it. He's the one that did change the document. He admitted it to two people in this room that he mismanaged this whole thing. He admitted that he said that Timothy Dooley's vote should be null and void, and statute, in the Ethics Commission statute, there's a statute that states that also, this is another subject, but you can clarify that one, that if Mr. Nelson is the one that nominated him and he is the owner of Fellsmere Joint Ventures, which Timothy Dooley works for, that he has to abstain, his vote's null and void. He can't partake in that. And it's in the Ethics Commission statutes. So technically, from what I read, it states any employees or family members, and he can't partake in the voting.
What he's saying is your vote is what nominated.
John,
solely.
let's
Yeah,
not do the back and forth. You have your time to speak. It's Grant's time.
I'm not.
You are speaking. It's Grant's time.
That's basically it.
All right.
I'd like to speak on that topic.
You already spoke on that topic.
No, I
President, would you like to allow him to speak again?
Is there anybody else back here?
I'd like to give my time to John.
There you go. Mr. Nelson, all we're saying, yeah, go ahead. Hello?
Takes a second to warm up.
No,
It's on now. It's on now.
The 70s Ford.
Hello? Mr. Nelson, what we're trying to say is your 18,000 votes, which should be respected, is solely the votes that elected your own employee when you're a sitting president on this board should not be voting for your employee, which is the vice presidency. And while I got the mic, one more thing is the floating musical lots that I believe Richard gave to him 3 days before the election, which even that is wrong. And I'm not going to say any more to that. I'll let you speak.
You only get one vote, 0.004 acres, one vote.
No. So if you're kind of going down what's a complicated rabbit hole when you talk about corporations, and there are several corporations that are owners of the farm, but a corporation is a person pursuant to Florida law. So a corporation can appoint an employee, an officer of the corporation to represent it, and that's pretty solid Florida law for the past 70 years. So that's the part I think that you missed, is that the corporation is a person pursuant to law.
He's your employee. How is he going to cast a legitimate vote whenever he's your employee on the same board?
He'll use his own judgment as to.
No, I'm not judging it as a conflict of interest. That's all we've been saying all along.
There's an attorney general opinion about corporations and voting, and that's contrary to it. Corporations cannot do that. They can't vote with their 18,000 votes. There's an attorney general opinion on it. Look it up, or I'll bring you a copy.
Any other comments on this issue?
I can slightly, it says state public officers are prohibited from voting in any official capacity on any measure which they know would ensure to their own special private gain or loss. A state public officer who abstains or who votes on a measure which the officer knows would ensure the special privilege, gain, or loss any principal by whom he or she is retained of the parent organization or subsidiary or sibling of a corporation principal by which he or she is retained, of a relative or of a business associate such as Timothy Dooley, must make every reasonable effort to file a memorandum of voting conflict, which I don't think that's been done. And if you can't do it, it has to be filed 15 days after, which, unless that's been done, because I haven't heard, I've never seen anything that any, you know.
So you're saying Mr. Dooley receiving compensation?
No, it's, the read is, it's if he works for you at Fellsmere Farms, those are joint ventures, SIAC, whatever you want to call it, he's an employee of yours. You're a board member. He has been nominated by you, owner of the business and a board member. If he can vote any way, shape, or form that benefits you, the farm, then you need to abstain from voting.
I would disagree with that. The vote that was being taken wasn't a vote on the,
Okay.
he wasn't voting as a board member. He was voting the landowner's ownership, the proxy at the landowner's meeting. So any landowner can elect, a landowner at that meeting. It's not, that rule, it's true. He couldn't vote for one of his employees to come be employed by the district. That would be, except that we're in.
That's okay.
So there's exceptions to that as well for 298 district itself. But in this instance, as a landowner, that landowner property is irrelevant to the.
That's your opinion.
Anybody else on this item?
I do, you asked, Mr. Nelson, you asked him, was he compensated? Is he the owner of the Elm Street lot that Richard Cardelli used to own? That's the lot he owned 3 days before he election. $100 warranty fee. That's not compensation, I understand, but I'm just recapping for everybody what we're looking at here.
Anybody else?
I'm done.
Mr. Dooley, how long have you lived in the Fellsmere area?
He doesn't.
Just in your county resident?
No, that's not what he asked. That's not what he asked.
You don't live here.
That's not the question. I asked you how long have you lived in the Fellsmere area? That's a fair question.
Since 1988.
How come no one here has ever seen you around this little town of Fellsmere?
You're a resident?
Yeah.
I'm a resident in Washington District since 1988.
Thank you. Thank you for your time.
Well, swear again. Timothy Dooley, do solemnly swear or affirm that you will honestly, faithfully, and impartially perform the duties involving upon you in the office to which you were elected as supervisor of the Fellsmere Water Control District, and you will not neglect any of the duties imposed upon you by the Florida Constitution, Chapter 298, Florida statutes and laws of Florida.
You do?
One wrong item B, Mr. President.
How did we do that without a quorum?
Exactly.
How do we swear somebody in without a quorum?
Takes two,
Takes 2 to 1.
takes two to get quorum, right? 2 of the 3 board members?
I'm not sure what you're
After the election, you have to swear in.
You're speaking out of order.
Yeah. Okay. But we're gonna have to keep the comments one, you can speak for 3 minutes in total, but we just can't keep going on. I'll just say for the record, I'm very confident that we comply with the statutory requirements, and I don't think it's a good use of our time to try to debate an interpretation here, but I'll just say that it's very common practice that representatives of corporations serve on the boards of 298 on a regular basis. So, Mr. Dooley now being sworn in, we have 2 board members, so we can take the next action. And that is the appointment of a new supervisor for retiring the supervisor Kurtz. And I know that we have 2 candidates who have indicated an interest, one being Grant Danstein and the other being Steve Parentella. And Steve, are you here? Okay. So I've never met you before. And so I'm in a difficult position here because of a filing of an ethics complaint by Mr. Grant Danstein, which means I should not have any contact with him whatsoever because he could be a witness and any conversations could be interpreted as trying to influence that witness. So I feel I have no choice here but to nominate Steve Parentella, or better yet, Kim do that, and I can second as the chair. But that's the awkward circumstances that we find ourselves in at this point.
We want to thank you for giving us a voice anymore.
I'll make a motion to nominate to appoint Steve Cranfeld to the supervisory position of retiring supervisor Curtis.
So I second that motion. All in favor, aye? Aye. So, Steve, now you're on the hot seat. Have any second thoughts at this point?
Stone.
Mr. President, before we move on, we want to just quickly revisit our,
It is swearing in, Mr. President.
Yes, we need to
oh, yes, thank you.
You, Stephen Parentella, solemnly swear or affirm that you will honestly, faithfully, and impartially perform the duties devolving upon you, the office for which you were appointed as supervisor of the Fellsmere Water Control District, and you will not neglect any duties imposed upon you by the Florida Constitution, Chapter 298, Florida statutes, and laws of Florida. You? I don't know the answer to this question, let me say it ahead of time, which is, the appointment of the seat is only through the expiration of the seat you're filling until the next landowner's meeting. I don't know if that one voted it up for a re-election next year or not.
Yes, his seat is the one that's open for election.
That was the case, that this position will only be for the year until the next landowner during the next election for the remainder of that term, and since then we'll do up anyway, that makes it easy.
Next match.
And I was going to add that if we want to revisit the organizational structure, the way it currently sits from our May meeting is Mr. Nelson is president, and I believe Mr. Wheatley is the assistant secretary, and that would be Mr. Parentella as the assistant treasurer. And that's okay with the board. If not, we need to revisit that.
Yes, we do a lot of work.
Check. We'll back in that.
Are those positions acceptable to the board?
Yes, they are.
Okay.
So maybe we should make a motion to that effect that.
We have since Kurt before, let's make a motion to appoint supervisor.
If you could get that motion.
Then I move to appoint the
The, what's going on with the work packet, and there's minutes in here that are incorrect. There's, public member, there's no name, who spoke.
Which minutes are you looking at, what page are you
Well,
looking
it's all over the place. It's not just on one page. It's in the area that says if you just put a public member instead of that down, and you,
No. Number 3, several places.
I mentioned it earlier about the no discussion, it was just going from a motion to a second and then a vote. And here's another one, approval of procedures that you put on the table. You didn't tell me when they changed the procedures.
at? Looking at the landowners meetings, that's not the minutes that are being approved tonight?
Yes. That's it. That's correct.
We're only approving tonight the board of supervisors meeting. The minutes to the landowners meeting will not be approved until the next landowners meeting.
If I wasn't talking about approval, I was talking about.
There's times to make those corrections.
Well, yeah.
So I understand the request to be put in people's names rather than putting.
And I'm going to need help because I offered at the meeting, that if you want your name in the record, state your name, no one chose to state their name. So I'm going to need help if you want to put names in the
Okay.
record.
Yeah, you really have to recognize the voices.
Well, the bottom line is you have to have correct minutes. You have to be, really, these are legal documents. They have to be correct. I've done minutes in the past many times.
And if you'd like to be with me out of this
I
meeting,
can be with you. There's a lot of language that's in there that's not true. I'm not saying you're lying, I just say it's not true. It's not correct with that.
So if you have anything specific on the board of supervisors meetings, please
No.
share.
No, not this one.
I have no other comments on this, sir.
I'll just note that the correction says last name is B-H-N, not B-A-N.
I wish it was spelled that way. Here on the line, let's see.
With that correction.
We move to approve the minutes of the May 2022 Board of Supervisors regular meeting, including that correction.
Second. All in favor? Aye.
Aye.
Okay. Regular board meeting minutes. No action is really required on the landowner meeting minutes, but because that will be approved at the next landowner's meeting, but it's duly noted that it has some details, specificity on who is speaking, we can figure that out. Okay, so next we're on to engineers matters, open permits.
We had a request to speak with Josh Miller. Did you want to speak now or wait for me to say that?
Yeah, I just want to, and I've said this in the past, we meet with the city of Fellsmere line. I'm just working for a district, we do what our city do. I'm just going to recommend Fellsmere Water District to create some oversight on their building. You know, there's a lot of projects that have listed here for permits, they get permits from you. I want you to consider the flooding that we've experienced in Harvard here, and the more infrastructure coming. It seems like the city of Fellsmere doesn't really have a hand on the engineering scale, so to speak, to hold them to the accountable for pre-treatment or understanding what the impervious ground calculation is going to do to our already flooding situation. So I'm not going to beat you out on maintenance, but growth is a big part of treating rainfall, and it needs to be looked at. I'm just recommending on that item for you guys to try and either create a policy that the city has to get approval from you first before they issue a permit, so you're looking at the overall impact of the system from growth, or vice versa. Either way, there should be some team now you have to deal with the aftermath and the impact to our system. So that's the only comments I have on that.
What I intend to do is to make this an open item for each meeting, just to keep the board aware of what permits are outstanding. This is my first review of the permits to date, where they are. So it's a list of open active permits, some with issues, some without. And of course, those with issues that were approved either directly with the applicant or have to come back to the board for direction to do that. I'm really asking for no direction now, just information. I have any questions, I'll be glad to answer.
Mark, how do we categorize like the engineering projects that you're overseeing?
John, I know you love to have this back and forth, but
No.
we're not having it back and forth. If you'd like to speak, fill out a form, and you'll have your 3 minutes. If you want to stop the back and forth.
I did fill out a form, Mark.
Okay, so, go ahead. On the side, if you didn't have on the side, go ahead on the side.
What I'm asking you is, because you're now the new acting engineer or whatever, how are we categorizing these projects? Like, is there, like with, George, there's, a code, which I would like to understand that, but what is your, like, you're gonna categorize that with the code, so we know which one is which job is which?
It's permit number, so yes, I do have a permit numbering system that I'm using. But there's, the type of applications are all spelled out in our design manual and our application form. So those types are, your culverts, your secondary drainage, your withdrawal of water, your typical development. And it's the development ones that are the more complex ones that require consultant assistance. And those are the ones that George often did, which now we use by continuing to use.
Okay. But there'll be some type of record that, stuff that you're overseeing.
Yes, and they should be all here on this monthly report or every other month when we it'll be on this list.
Yeah.
For the board
Thank you.
to see.
Mark, can I also ask this? Is that something that can be posted on the website when these permits come up? You can look at the county, and we can go.
It can, yes. It will take some time to make that happen. And we're just squeezing that into my daily routine and getting that modification done. But yes, it can be done if that's desire of the board. I know prior direction before I got on board from the board was to keep the website as basic as required by statute. To minimize the timeliness issues and the timeliness issues, but it can certainly be applied. That's the will of the board.
And I think one of the reasons why I'm sitting up here is because we need more transparency. And just that simple task of putting those on the website as they come in, people can take a look. The residents can say, what's going on? They can see it in real time.
I actually talked to a citizen group some time back about doing something similar to that, not just current residents, but maybe historical ones that we can see at the time. But yeah, that has been talked about internally, just not to the world.
At the risk of getting mad at you, Mark, you still have it closed on the website that the office is closed. Ever since your vacation, it still says.
It's probably still there, yeah.
Yeah, I just wanted to bring it up to your attention, you might appreciate that.
Thank you.
Thank you.
No problem.
Yes, I, Rusty Mack, our family, I'll just speak loud enough. I just wanted to address, the board, I may have one of those open permits, and I don't like my family, tied to something that's not finished, so, it's something I think that needs to be discussed on for everybody in this room as landowners in the Fellsmere Water Control District. And part of this is we had 30 acres of Babcock Road that was agriculture. We're still in the citrus business, still planting actively, still staying in the citrus business, but for reasons, growth and high salinity water and other issues, we do not farm that anymore. We were getting complaints from people driving by, with spraying, and the spray was getting on the car. clean the district right-of-ways, district ditch right-of-ways. And my issue with that is, and we running into it over on 85th where we have other property, is that we've paid taxes for this district for probably 60 years, our family's owned property in Fellsmere. And these ditches are never cleaned. Pepper trees growing all along, and I pay taxes to have those ditches cleaned. And now I go to put in 3 culverts, and they're wanting me to clean all their right-of-way to get their pound of flesh. And it's just not right when we pay taxes. And being farming up here for years, where we've had rain events, I've had to take my own backhoe, and I'm lucky that I've had a backhoe and clean culverts out so water would drain out of district culverts, whether it be debris from pepper trees, furniture coming down from Carter Hall, plugging up culverts, and, you know, these increases in taxes, personally, and I'm just speaking for myself, I don't mind paying for increases in taxes if the work's getting done. And I've been involved in many districts, and I'm still involved in the Delta Farms District, and we set a budget to get projects done. And we pay those fees for that reason, and we administer and get those projects done. It's not being done here. And I'm just speaking for somebody that's been involved in Fellsmere for a long time. And, you know, I just don't think it's right. You can go on any road, and I'm over my 3 minutes, so I'll shut up, and just look at the overgrowth of pepper trees and everything else that are plugging these ditches, that fall into ditches. And it shouldn't be the landowner's responsibility to clean those ditches when they're paying tax to have this done. And I think that needs to be addressed when culverts are going in, and all of a sudden, it's the responsibility of the landowner to go clean the ditches that the district should clean.
I have nothing else on this side, Mr. President.
I have a question.
I'm going to just respond to Rusty, and I understand exactly what you're saying. It's all a matter of cost. And, you know, when you compare the cost of what you pay at Delta Farms versus the cost here, you're less than half on a per acre basis, but yet there's 20,000 acres to clean here, and, you know, frankly, not a tenth of that over there. So it's a lot to manage, and there's just not enough money in the budget to get to everything without increasing the assessment, which in the past, when that's been discussed, has not been popular. That's, you know, you're a friend, and I understand the predicament, but, and we're certainly looking for advice, but that is the situation we have. So it's often going to what the worst one is and trying to address that as a priority.
My only comment to that, Greg, is that's fine, but don't put the onus on the landowner to clean that ditch. And have it, I just, over on 85th, cleaned a half a mile of right-of-way ditches that Fellsmere Farms Water Control District should have cleaned. Took all the pepper trees out at my cost at about $2,000 to $7,000. Both ditches are totally on district right-of-ways. All those pepper trees were growing over to my grove. I'd have to take farm land and catch those pepper trees every year because they're encroaching on my grove. So I've done my part to keep these ditches clean, but don't come in there and tell me I have to clean them out because the district can't afford to do it. That's where I'm saying it's not right.
I understand what you're saying, and I understand the sentiment exactly. I mean, I could be saying the same thing, because we haven't had any ditches cleaned on our property, but one out of 30 miles and a half mile in the last 8 years, so I get it. But I'm just saying that for the benefit of people here, to be able to be that responsive, it means increasing the budget, which means increasing the taxes. So that's the decision that has to be made.
Yeah.
Josh.
Sorry, I didn't have that on my items up there because I wasn't going to discuss that, but he does have a valid point. You made it clear that you pay a lesser assessment if you do your own maintenance, and you can't play that card with us. But
We pay the full assessment on
why should we still be responsible for doing the work for you too? Because that's how it's interpreted, and I was gonna get there when we got to the demand letters, but, you know, to demand someone to take something out of your right of way, when you're having been doing it for so many years, it would never be where it's at, it was being maintained all along, and then it increased assessments on top of that seems kind of wrong. Seems like a double standard.
Okay, what are you saying? I'm not understanding the part about taking something out.
Yes, if the ditch is grown up and it needs to be taken out, cleaned out by the drainage district, but you're gonna increase assessments and tell the person that's adjacent to there that they're not maintaining it either because they planted trees too close, now they're encroaching into the right of way, and now they have to clean it out of the right of way too. It seems, you know, a little bit like a gut punch. You're gonna pay more, and by the way, make sure you clean up the area there that's on your property line that's in the right of way too. That's how the demand letters are interpreted. That's what Mr. Bennett is getting at, I believe.
Okay. Well, thank you for that clarification. I think that's from the, well, that gets complicated on what kind of trees they are as well. Who planted the trees? That all becomes kind of a factual investigation. Mark?
Mr. Nelson, I have a question on bullet point number 7 under open development there. I'm just curious to understand how the FJV water farm works and what was your incentive to build that water farm and how does that play into the district's activities?
I'm sorry, you said number 7?
It's the 7th bullet point under open development, under open permits.
Page 14.
Page 14.
Page 14 in the agenda item. It's the 7th bullet under open development.
It's an open permit.
It's FJV water farm lateral U connection and withdraw for stormwater treatment area. I'm trying to understand what it is that is the reward for FJV to build a water farm. And it seems to me that if you're taking water out of lateral U, then you're using lateral U, that's part of the district. And I guess I'm trying to understand how that plays into you not using the...
Okay. This is a drainage district. If anybody wants to pull water out, as far as I'm concerned, that's a good thing, to pulling the water out, because our issue is that the drainage is slow, right? So anybody can get a permit to pull water out of the district. It's about putting water in and taxes the maintenance of the district. It's about the drainage. But pulling water out, you can apply for a permit to pull water out. That's not listed as a benefit of a drainage district.
And does FJV profit from that arrangement?
We get compensated for the amount of phosphorus and nitrogen that we remove from the water for the environmental benefit. And
Per gallon.
what's that?
Per pound, I'm guessing.
Per pound of nitrogen, per pound of phosphorus.
And who pays that? Who pays the...
The St. John's River Water Management District pays for that as an environmental benefit because they're trying to keep the seagrass from dying in the river.
Thank you.
$22 million.
No.
That's what the article says.
But
22 million in 13 years pilot project, FJV water farm. Yeah, 22 million.
I wish that was correct.
It's probably not correct. I have a question about the water farm though. How do we cover engineering costs with a $400 permit on a 1,600-acre job? How do we do that? It's a $400 permit.
It's called the retainer that is collected. And if more money is spent than the retainer's value, they get a bill at the end of the project. That's usually the last thing that happens before we close out the permit, in addition to getting as-built drawings. So once we get the as-built drawings, I'll send them the bill. If there's a bill that needs to be sent, they'll pay it, and we'll close out the project.
The drawing is at your office.
I'm sorry, what's that?
The drawing is at your office. I've seen it print.
As-built drawings?
Oh,
I think the mic's
fine,
down.
fine.
Maybe. Reset it.
I got it. The water. You're setting
Give me a test.
Tap it, Grant, just tap it.
It takes a second.
There you go.
The water that goes into lateral U comes from the west side or east side.
Right.
So we're subsidizing the water that goes into that ditch.
How do you subsidize?
Well, it's flowing from east to west.
And then otherwise it's going to throw back gravity.
And it goes into
now.
the pumps down there.
Right.
And then the pumps pick it up.
Yeah.
So you're getting paid to do that.
We're getting paid to remove phosphorus.
So we're subsidizing that.
How do we subsidize?
Well, without the water coming into that lateral U canal, you wouldn't have water.
Tax.
Okay, but
I'm just saying.
the system was designed that way.
Oh, yeah, I know, but it wouldn't go in there. You wouldn't have the water if it wouldn't go in there. I'm just stating a fact. We're subsidizing.
If there wasn't water,
We're subsidizing for you guys to be able to pump water out of that canal, so the district should probably get a percentage of that.
if the district didn't have dirty water, we wouldn't be cleaning it. That's essentially the
So
issue.
then you wouldn't have a farm.
You're making money off the taxpayer dollars.
Okay, that's a decision of the St. John's River Water Management District. That's not a decision of the Fellsmere Water Control District. It was publicly noticed, published. They asked for people who would be interested to take on this pilot project, and we put our hand up and said, we would try. We haven't made a dime, and we don't know if we'll make a dime, okay, because this is a first. Thank you.
How do you weigh that, Greg?
How do you weigh it?
Yeah, the phosphorus and nitrogen, is that a scientific equation?
There's a third party that comes, engineering firm at the district's direction, and they do the testing of the water going in and the testing of the water going out. And
So
they
it's
do
got a
all
scientific
calculations.
equation.
Yeah, it's a third party that makes the determinations. That's what I say.
Thank you.
We have no idea
Thank you.
at this point.
Yeah, we don't either.
Ready for the next item, Mr. President?
Yes.
Attorney matters?
Seth, Attorney's Matters, please.
I don't have much that isn't on the agenda. This is about the time of year we're usually giving the end of the year legislative report. We have a team up there in Tallahassee, and we represent the Florida Association of Special Districts, who will extract bills that might have an impact on special districts. The report I gave at the beginning of the session is we had a couple bills out there that we were kind of hopeful about. There's a couple of things we've been trying to get through the legislature for many years. One of those is to go from a newspaper notice to being able to do it on our website. A lot of areas don't have a newspaper anymore. It's a costly thing for districts to do. And we actually had a bill introduced this year that had that provision in it. That bill didn't make it anywhere out of the house. As far as bills that were problematic and having issues this year, sometimes good news is good news in the special district world. We don't have the target on our back. It really wasn't the case this year. There was kind of no harm, no foul in terms of what came out of the legislature. Obviously, the governor took his veto pen to the budget and struck out a lot of water bills out there. Again, nothing with direct impact to Fellsmere, but that's something else we also track. So it's kind of one of the services that Illinois Water does provide is we do have a legislative team that tracks these things every year. And so we keep our ear to the ground and try to make sure that the special districts are up there in Tallahassee. So some years we'll take the news as good news. That's the conclusion of my guide.
Thank you, Seth. Next is Managers Matters, number one, financials, Mark.
Yes, standard financial report that put together. This is for April, so the next meeting we should have May, June, possibly July as well. We're tracking fine. There is going to be a discussion of a budget amendment for this year to cover the spring, putting together we'll cover that in detail at appropriate time.
Thank you.
As far as our management reports go, I'll just let them speak for themselves. If you have any questions about what I was working on those 2 months, just give me a holler. I'll be glad to clarify. Status of sub-lateral inspections and cleaning. The operator's report has been changed to a weekly report instead of a monthly report, so that we can keep better tabs on his productivity. This is the last of the reports here in May. We're still tracking to hopefully have completed the cleaning of all the worst of the worst ditches by the end of the fiscal year, which will hopefully line up with the spraying cycle, so we're not spraying overly vegetated ditches, so it has more effectiveness to it. This particular map is JMG 13, so obviously it's a few years behind. And in the process, I'm also identifying the overhanging limb problem, because one of the items on your agenda is tree care. And so we're going to be updating this figure in the future for overhanging limb percentages, just to help you guys where that contract will have to work when the time comes. And the next one is a potential grant opportunity for the Milton hurricane that came through. We really didn't have a lot of damage, but what usually happens after these types of events is you have funding for repair, but you also have funding for future mitigation. And so I'm looking at this potential application to see if it's suitable for some mitigation type of work that might be appropriate for us. Understanding, I believe, that the needs that we have, I think the most important is gaining access to all of our sublaterals. I've mentioned many times that some of our sublaterals have been overgrown and thin, where a landowner may have blocked the road, and over time, just regrew. And also at the end of those ditches, if we can't get to it to maintain it, that means the ditch itself is not maintained. And so we do all that effort to clean the ditch, and then you have a plug right at the very end before it goes into the park bottom. So it would be my recommendation that if this is a grant that works for us, the application cycle is the end of September, so we'll be able to come back with a final application in September. The board's approval, if that's their desire. But I intend to move forward looking at this opportunity, and more than likely move forward with that as a potential mitigation project. Basically restoring access and the condition of our outfalls.
Do you have any number in mind what that grant would be dollar amount?
It's based on what your need is. There's not there is a max, but the max is way over what we ever need. It's the minimum usually that we have to deal with. I think the minimum is hundreds of thousands of dollars minimum. So our project has to at least cost that much to get there.
Okay.
I think the other thing that we have to do is in the September meeting, we have to adopt a bunch of CDBG specific policies, because when you do a CDBG grant, you're at a higher level of policy control than normal. And so you have to have it approved to the state that you have all these policies in place. I sent drafts of those, and they were really just a copy from the city development operating procedures, because they've been doing CDBG grants for quite a while. But we still need to have those in place, or you're not going to be able to do this.
What's the deadline for snow?
I think it's September 26th, I believe it is.
So they have some time, but we need to come up with some ideas.
Well, I'm looking forward to that one I mentioned, if you think of any others, feel free to share, but I really think that, there's other ideas we'll talk about, canal shells for maintenance, but, we just did a major canal project, probably going to deal with that for a few years. There's some other ideas I'm sure we can help with. Mr. President, there's somebody in the audience who'd like to speak on this issue.
Yes.
Just a couple items. I'll go with number 3 first, the status of the sublateral inspections. Have you had any feedback from the county related to the grading as far as the spores being away?
No, I've given up trying. I've tried.
No, but you got any input from them saying, hey, what are you doing this?
I got anything out of it.
Okay. So I'm afraid you're going to now get back in the ditches. That's what
Well, I am trying to keep an eye on that to see what happens.
we basically, had a big deal with the city to set that. But anyways, those two should be developing, so I need, your water bill plan is pretty clear on what you need to follow. I know it's 25 years old, but it's detailed in your, what your maintenance obligations are already, according to your goals. Thank you.
I'll speak to the grant for a second.
Okay, keep it brief, please.
Real quick, I just don't want, like, we're talking about grant money, this is like new territory for us. I want to make sure we don't end up like a city and not meet the requirements of the grant when we've already spent the money and now they owe money back that they don't have. Just, that's short and sweet.
Fair warning.
Thanks, sir.
That's all I have on management matters.
Okay. Now we're into the consent agenda, after J.
And I have no member of the public requesting to speak on the these, so these can be done in a group manner if you choose.
Okay. Sorry, Steve, for throwing you in there, but there's a fairly boilerplate approval of, I think, as a second depository, second bank to deal with. It's good to not have all that money in one place. Designated registered agent.
That would be Seth Payne's office.
Okay.
That's basically where all legal notices go.
And rail trail right of way use provisions.
The reason why I put that in your consent agenda is because that action's already occurred administratively, so it's really more for information purposes. It's just letting you know the conditions being imposed upon the city for that particular grant. Most important condition is that we have a 25-foot easement along the railroad ditch for maintenance purposes. In some locations, their trail falls within that 25 feet, so I made it very clear from the conditions, even spoke with the city attorney on those conditions, that if there's damage to the trail or any other facilities because of our routine maintenance, it's not our responsibility to repair it, because they're, in essence, in the easement that they granted to us.
Okay.
What type of maintenance do they require to perform
The city has no maintenance requirements unless they put something in there, like, for example, the trail or the fence, or they do something else, we have to maintain the trail like we do any other recreation facility. We do the maintenance of the ditch. They do also mow it, so I would say they mow as well, right away, so they do mow it. I don't think they mow it regularly because it's quasi forced through there, so. We mow it in there.
Okay. Now, into old business.
Actually, was there a motion approval?
Oh, I'm sorry. Right, sorry.
Move to approve the three consent agenda items, specifically resolution 24-2508, resolution 24-2515, and the permit conditions for the rail trail practice.
Second. All in favor, say aye. Aye. Motion passes. Now, business, amendment lease agreement for the additional machine hours on our excavator.
Yes, we've talked about this quite a bit. I don't know if we're going to go into much detail. The hours in the upper right corner of the maintenance sheet at 1,075 hours. We're about 75% through the lease year. So the 1,500 is not a bad number to have, and that's what we purchased. And it costs us about $7,000 each year for a total of a little over $23,000 for the 3-year period of lease. And since we're already in year 3, that full 23 is due as part of the last lease payment. The figures are in the June package.
Okay, so really no action taken.
Actually, no. There is a request to speak from Mr. Miller, but yes, I do want approval of the lease agreement.
Okay.
It might be a typo, but it says upon return of the current machine in January 2027. What does that mean?
Well, that means that's when the lease expires.
Okay, also you're returning it to them in 2027, that's not, okay. And I just wanted to clarify the next sentence. It says that however the sub-levels are returned to regular maintenance, and then it talks about the frequency of mechanical pinning may be reduced. I hope not. I hope that regular maintenance
have no idea if that's gonna bear out or not. I just hope that, when we get to regular spraying, regular maintenance, that I don't need to be going through 50% of my ditches every year, which is on pace for what we're doing this year. We're probably on pace to get to half our ditches in 1 year. I'm hoping I don't have to keep that pace, that's all I'm saying. It'd be nice if the operator would do other things that are needed, put a different head on the machine, grind trees, put a different head on the machine, and know some things. So, I mean, there are other things that'd be nice that we'd be able to do, but obviously I don't think we can afford some downtime on it.
Mark, what was the increase in that? Because we were at 70,000 for 3 years. What are we at now? 93?
93 is only because we're doing all 3 years in one payment, so it was about 7,500, 7,800 numbers in the bracket per year, so that adds up to about 23,000 for a 3-year period. Yes, sir.
Bart, I've got one more comment about this maintenance and there being fairness. Most of these laterals, you have a landowner on each side. One does not have a culvert. He gets the same benefit of that drainage as a guy that has to put the culverts in. But I'm going back to the guy that puts the culverts in that has the property on that side is the one being responsible for cleaning that ditch. Where both sides are sharing that ditch. So why is the responsible party the one that just happens to be on the side of the ditch versus?
That condition placed under a permit was a new condition by Mr. Simons before I got here. I had asked
I'm
him
just
why
saying
he
it's
put
not
it
fair.
there.
It's not.
I think the issue is that those trees were planted by the farmer decades ago.
Decades ago. I didn't plant it.
I'm not saying you did, but somebody on that property decades ago planted a windrow of Australian pines, just like multiple other areas in the district. They had no problem maintaining the Australian pines on their side of the property line, but they didn't care about what happened on the other side.
I get the Australian pine, but it's not, I'm just saying for every landowner in here, you have that issue that the guy that is on the side of the ditch that has the culvert, if y'all are gonna make him responsible.
We're not.
Okay, well that's, I just want to
We're not.
clarify that, and then going back to the Australian pines, the ones that are growing, I mean, they send out a sprout from the roots, and it just would have taken somebody with some crossbow to go down there once a year and spray those little suckers coming up in the right of way, and that problem would have been there. So I'm just saying it's a shared responsibility there, and
We'll be covering that later today.
okay, I'll get with you on that.
Thank you.
Hi, I'm Lily. In regards to the lease, did you say you paid all up front in 1 year?
No, it is we chose an annual payment.
Okay.
They usually we go more frequent payments, they charge a little bit more. So we chose annual payments. We're 2 years into the lease already, so 2 of those payments have already been made.
Gotcha.
So all the increase fell on the last year.
Okay, so we're actually saving money by paying this.
I don't know how much, I have to go look back at the purchase docs and see what the markup was for less frequent payments.
Okay.
More frequent.
I guess I misunderstood. I thought you said we paid an additional $23,000.
We are paying an additional
It is.
23.
It
Because
is.
when the lease was originally issued, it was only issued for 500 hours a year.
And we went over the
We
hours.
went over that mark,
So, okay,
so that was why we
I
made 23.
I understand that. Thank you.
What about the operator? What
about the operator?
New operator, have we searched anything out on him?
We have a job description, I'm just sending it to the district attorney for his blessing, and then we're gonna put it out on the street. I'm ready for having my presentation decided, so if there's a motion to vote for this.
Okay, so we're at L1, amend the lease agreement for additional machine hours. So we need to approve that. Okay, motion to approve that, need a second?
Second.
All in favor, say aye. Okay, motion passes on the amendment for the machine. These terms. Next is the amendment contract for tree removal.
We have an open contract for tree removal. That contract was put on hold when we uncovered the potential Australian services being done. And obviously, the vendor is okay with this. They haven't done any work, they haven't done paper, so everything's good there. And if you want to go back and deal with the Australian Pines as a district issue, we just issued a contract for the vendor selection. Go from there. So this is really just to get board's concurrence to in the current tree removal contract as is. Basically, a couple small tree issues for us to take care of. A fallen oak on 107th, I believe it was, and they took care of a couple of Australian pine branches that were over the mound, and they trimmed up some trees in the office.
Okay, so we're effectively canceling this contract.
The remaining part of the
Remaining part of the contract, terminating now.
The contract has been agreeable.
Yes, he's been paid, or she's been paid in full for the work she's done, and she's agreed with time. She's a choice. When we had talked to her, she's okay.
So I have a motion to cancel the contract on tree removal.
I would move to amend, excuse me, to cancel the contract for the tree removal vendor.
Second.
And just for clarity, that's the remaining portion of the contract.
Yeah, just the remaining portion. All in favor, say aye. Aye. Motion passes. And now we're on to approve contracts for continuing engineers.
I did receive the contract from Mr. Bain's office, and sending that to the three selected firms. And in the meantime, if I need any work, we'll just doing hourly work from them until we get these contracts executed. And so I actually don't have the contract in this packet, and it hasn't necessarily come back from the consultant yet for any comments. So if it's okay with the district attorney and the board, I'd like to move this item to the September agenda after I've gotten the final blessing from the consultants on the terms of the contract, their hourly rates. In the meantime, I can use them to just hourly task orders.
Okay,
As
so
long as those hourly task orders are less than 35,000, so it would be way less than that. It does not require competitive selection for the CCN.
we're going to delay, postpone the contracts on continuing engineers for further information and experience with them right now on an hourly basis. So need a motion to, well, I don't know. Yeah, don't need to take any action. Okay.
I have a question, as one of the items I put on the comment card. It says 3 selected firms. You already selected 3 firms, or you're putting it out for a few?
No, we already put it out, and at the last meeting. we
Microphone,
talked
please, Mark.
At the last meeting, we talked about the 3 firms and what their roles were going to be. So at this point, it's just executing the contract.
Okay, so do you have the names handy of the 3 firms?
Full Pepper Interpreting,
Okay.
Bowman Consulting, and Royal Consulting.
Okay, so your intends to use all 3 then, or just?
Yes.
Oh, okay. So
On a rotating basis.
I got you. That's the way I read it. I just haven't seen that before, so
Yeah.
I figured I'd ask. Okay. Thank you.
Okay, so now we're on to new business. Number 1 is the amended fiscal year budget for aquatic maintenance.
Yes. When I first started, we did an amendment to accommodate the different costs for administration, and it left the budget somewhat bare. However, during the course of the year, we uncovered over $200,000 of savings that were in the budget that were needed. One was related to a lease payment to the machine, saved us $77,000. The other was the canceling of the remainder of the contract for Park Lowell, which was over $100,000 in savings as well. And I think it's appropriate to reallocate that money back into a spray before the end of the fiscal year. My plan is to have the tree care, which will be Most of the changes are just to reflect trends, but the big changes are on the second page of the budget that deals with the spring. You'll see where there were zeros before, they're now, $60,000 and other numbers to address what I just mentioned. What we're finding is that kind of the building's great, but it may buy you 6 to 9 months, and the vegetation's going to be back again. So you really need to get started on your spraying so that you get the benefits of your annual cleaning a longer period of time and have less need to go back and manually clean quicker. And so, if you have any questions, I'm glad to answer. But the only difference with this particular budget is that the overall expenditures will increase because we're bringing in some money from reserves. And because of that, it's a major budget instead of a minor budget. And we work to set the office to get the right advertisements in place and the paperwork in place for September approval of this budget. Any questions, I'll be glad to answer.
What page are we on?
On page 34.
I have a question. How does this work with carrying forward these monies from reserves? How much money do we have in reserve? And how did we decide to just all of a sudden carry forward a bunch more from there?
Well, we have about $700,000 in planning, and we make those decisions with each 3 board members sitting up here every other month.
So we're just eating into our reserves.
No, we're not eating into our reserves. This money was already allocated to be spent. The reasons it was going to be spent didn't occur, so we're reallocating that money to something else.
I'm sorry, would you say that again, please?
The money was intended to be spent on a different item. It's not based on that item, so we're reallocating it to a different item.
Why, I'm confused by why it says carry forward from reserves. If it was just money that had been planned to be spent, but
Because
it
the
wasn't.
money that was planned to be spent was reserve money.
But the original plan was for $149,000 to be used, and now it's $237,000?
I have to see what numbers you're talking about.
On page 34, up there under revenues, the final line under above total revenues. I'm just confused about the accounting.
I'm the kind of person numbers speak, so I don't know how to answer that question. It's just simple math.
Well, when it says carry forward from reserves, does that mean we're taking it from the reserves? So we're taking more money than what we had budgeted from the reserves, so we're eating into our fund. I mean, it looks like to me.
I'm a little off on the words here for responding.
I'm sorry, we couldn't hear you.
Yeah, your mic's broken up.
Can you switch with rulings, please?
There you go. That one, good. Pull it to you, Mark. There you go.
That may very well be an accurate statement. That we're bringing in more money.
Okay, so, I mean, I'm just a little troubled by that because it seems like we're eating away at our own flesh to do stuff that we want to do without having budgeted for it.
Well, again, we went through a lot of changes this year, a lot of things that we didn't know how we're going to pan out. And as we learn, we adjust. And so that's what we're doing. We're learning and we're adjusting. You want your dishes clean? This is what it takes to clean your dishes.
Well, I'm going to ask that going forward, we have a realistic budget that accounts for those expenses so that we don't need to use our reserve for it. Let's spend what we have to work with instead.
So is the total of 90,000 difference here, and we're looking at total expenditures of 967 in the amended budget, and we're not actually approving this point, right? But versus 877, so we're talking about $90,000.
Correct. But of that 977, there, on the first page, you'll see at the top, carry forward reserves is 237. So even though we only went up 97,000, we are taking 237 out of reserves, but a large chunk of that was already in the budget to be taken out. That's why the 97 is different than the 237. So 140,000 plus the 90 gives you the 230.
But we're gonna make that decision in September.
Yes.
Okay. So no action to be taken at this time. Next is a resolution for approval of district fee schedule.
We have a member of the public, Josh Miller, has this on his list to speak.
Yes, thank you for that. At page 36, just have a question. Can you describe reasonable fees in the first whereas? And what's the basis for reasonable? And then on the second page, it's going up 6 times on the permit fee, which I'm not saying is justified or not justified. However, I think a public hearing is in order for that. I think you can talk to your council about that. It's such a big increase. I think the public should have an opportunity to express how they feel about that. I don't think it's public anytime soon, so I'm not saying it personally, but if I did something like this in my district, I would be a lot of heat for it. So I want to put that out there. And on your demand letter section, it says that failure to pay shall result in maintaining placing your property in eventual foreclosure. I recommend using maybe loss of title or another term that's less alarming, and it means the same thing. But you have remained unpaid for 90 days. I don't know if that's a legal time frame or not, but that contradicts your Mesa Park demand letter at the back where it states 60 days. So I think it should be the same language for both parties. Just pointing that out. That's all I had. Thank you.
Did you have a comment on that, Mark? Looking at the demand letter requirement, I don't agree with the foreclosure element there on the 298. We have the ability to, we have currently 12 repair plus a 50% surcharge. That's fine, because the maximum of the statutes, you may charge them double if they impacted the initial works and on, receipt they have not made the repair. So cost plus 50% is reasonable. I think the outcome post-meeting is that we apply to this following year's assessment total. So we have the ability to assess those costs against the property. We're not in the foreclosure business, I don't want to be in it. But we do have the ability to apply that assessment to the property owner's subsequent tax total, the following year's tax total. So under demand letter, that should be the process on page 37.
So I will allow you to give me some advice language for that. So if there is an approval for this, it would be subject to the revised language provided by the district attorney. I really have no presentation on this, and it's just a request to increase fees that have increased in decades probably. And I can tell you last time.
That's wrong. It was $100 just a year ago.
We paid 100.
Okay.
$100. It was $100 just a few years ago.
I just figured it was a big jump. A public hearing might be better than the public than just approve the resolution and the board will increase it 6 times.
Bring it back to the next board meeting.
It's up to the board, it's all up to you guys. I mean, this is not time critical.
Yeah, I think we better address it in September. I think we should consider something less than that 6-time increase.
Well, say, hey, get less money. I mean, if it's justified, it's justified, but I think if you present it in a public hearing setting and explain why it's that much, you know, or just a narrative that other districts are charging this or something, you know. It's reasonable and going up 6 times doesn't matter, you know what I mean? That's all I'm saying.
Or could you explain to me, it was a retainer, 1,500 was a retainer?
No, again, there's different types of fees that are paid. What we're talking about here is just your standard permit fee, paying the list period. Retainers can cover additional review charges beyond just the standard issue permit. And so, this came about, to be honest, through coordination with forces. We're pushing hard for increased connection charges. And, this was a way to do an increase for connections. Well, I haven't done the rigmarole of a connection study and all those kind of things that go along with that. Or whether or not we were legally able to do that, as a single purpose district.
That's good memory, Mark. That's good memory. We did talk about that. The 1,500 is kind of violent.
Well, again, that's the number that came out of the group when we talked. So, we all, again, I have no skin in this game in this regard. I'll process the permit whether I get $5 or $1,500.
But it was in the last few years, it was like $100 and then it went to $250. And now it's over $1,500.
So is there a motion to continue this to September?
Yeah, I make that motion. That was confused because the last meeting, that number, that's the way I interpreted it the last meeting.
Just so happens you have to be the same number. It
Yeah.
happens to be the same number, but.
Yeah, no, right, but if he didn't follow through, you kept the 1,500, well, it's gonna be a lesser amount for the permanent, you know, at the end of the day. That's,
Maybe some proportionality as to the size of the project that's being reviewed here as well.
Again, these are less related to reviewed projects. These are more related to simple, same-day issue permits, forward connections, secondary drainage. These are not raw land development of subdivisions and new commercial buildings. They pay these fees, but they also pay the retainer, which covers the complexity of the project. And the retainer, I think it's in this one also is going up. I think it's going up to, $1,500. Actually, yeah, 15.
So we're gonna defer on this until September.
Yes.
Need a motion to that effect, or just unanimous?
Ms. Diglett?
Okay. Now, resolution amend application form and district policies.
This is one that is somewhat touching on the issue of the Australian pines and the exotic infestation of the district right away by plants outside the right away. Because we have added some language in here. For example, if you look at page 39, under permit policy at the very bottom, number 3, you see where I wrote nor allow trees. So it says permitting should not plant trees or shrubs, nor allow trees or shrubs to be grown. I added that nor allow because we were, with the prior attorney, were working down the path of potentially making that obligation like the homeowner or anyone who had planted those trees in the past and failed to maintain them. So if we're going to move away from that as a district policy, there's probably some tweaks to this that we should do. So as a minimum, I think we should probably go ahead and discuss that issue of whether what's going to be the policy of the district in regards to invasive exotic species and their lack of maintenance by landowners, whether that becomes a district responsibility or if there's any way we can put some of that on the land. That's going to affect some of the landowners in this particular area.
I have a comment card on that when you're ready.
Let's hear the comment.
Okay. The thing that concerns me with the Australian pines and everything, I understand both sides of it. The biggest part of it that we're not legally looking at is those were not invasive species 90 and 100 years ago when they were planted. So from now, when he does his policy, we should not plant anything, just like really should be any planted under power line. People do it, but you can't go back 100 years old tree and say it's the guy that bought it 5 or 10 owners later that caused the problem. Mr. Nelson and Tim, I just want to, I'll always seem like the bad guy, but I'm not. I'm just pointing things out. On your policies page 39 at the bottom, and this is just the kind of double standards you're dealing with. It's like a voting procedure. Is Jeff, you got a mic?
Yes.
Yeah.
Hello? So what I'm trying to say here is, the old adage of what's good for the goose is good for the gander, which I mean, when you look that up, you'll see what it means. What applies for one should apply for all. And at the very bottom of that page, just as an example, nothing to do with the Australian pine trees, but again, 50 and 100 years ago, the people did not plant the trees. Someone else did, and the land use was completely different at the time. And they weren't even invasive species when they were planted. On the very bottom of the page, it says here that you do not allow backflow preventers or flappers or any of that. Lateral U at your west side is loaded with it. So you're actually, I'm not accusing you of anything, but because you're using the south end of lateral U as a water retention basin, you have backflow preventers on that whole canal. And even pumps, and like electric pumps to run the irrigation on the shade cloth blocks. And I don't want to get too far into it, but again, we got to what's good for one needs to be good for all. And if we all pay the same assessment, got the same service, there'll be plenty of money. And if there isn't, then we all got to pitch in and do a little bit to help out. So, and if I haven't made it clear to y'all now that your policies are not being, whatever you want to call them, are not being kept by your own board, how can we go any further than that? Because, I'll listen to you, Greg, because I know, I have a lot of respect for you and Timothy. I don't know you, so don't take me personal. But there's a lot of problems with this board and the drainage district in general. And it's not gonna get fixed overnight. But we can't say, where did that come from, Mark? Where did that policies come from?
A lot of this
He's copied it from somewhere. Here you go.
This is the language on page 39. If it has no underline or no strike through, it's existing language that's been there.
It looks like a caption of a caption, like you took labeled piece of paper or another copy.
No, it's a standard strike through and underline. If it's new, it's underlined. If it's being deleted, it's strike through. If it has nothing, it's been there all along.
I said what I wanted to say, and if you want to address it, you can. If not, I look forward to like a workshop or whatever, but we got to get to where we're all the same. We're all the same. We're all in this district. We're all taxpayers. And again, I have a lot of respect for you, Mr. Nelson. You've earned it to be part of this. But at the same time, we can't have policies that apply to all of us and not to y'all.
So if you be more specific on the area and.
The whole south end of you.
When you say the whole south end of
The whole south end of you has flappers on it, which is a backflow preventer.
Are you saying south where 512?
South of 512, the guardhouse, the whole shade block area, the whole canal, because you're using it. You've actually got 4 control structures stopping the water from going on north on lateral U. You're calling it a plug, but it's not, it's a gate. And a gate is something to let things in and out
not a plug. A plug is a plug. All of them ditches, there's, what is it, from 20 to 34, there's 14 of them, and then you've actually dug an extra ditch in between them for the road blocks. So I'm thinking there's close to 20 backflow preventers in use, so you can use it for water retention.
So you're talking about the structure that lie north and south inside the canal, correct?
No, that's for the water retention. The east and west canals all have flappers on the pipes coming out of the grove blocks. Grove and grove, like we do your shade cloth blocks. They do have it in there. And there's 2 electric sump pumps in that thing that I know there's not a permit that you're running irrigation or all that stuff for. And this can all come out in like a workshop or something. But we've got to get back to where we're all the same being. And we're not. At $50 and $10, we're not the same. Again, Mr. Nelson, you may not want to hear it. You're saying you're not connected on the west side, but all of your land drains into them sublaterals and goes to the end canal before you put it in headwaters. So you are putting water into the sublaterals on the west side. I don't want to make believers here.
I don't know, I think there might be some confusion between the irrigation and
There's no, that's something else that shouldn't be. You should have your irrigation ditch at the head of all of your sublaterals. I don't want to get into it too much, it'll be like a workshop or something, but there is a problem here. It's just like the election thing. There's a big problem here. And until we look at what the problem is, we're not going to get anything fixed. I'm done with it. Greg, look at that. Look at lateral U, and then roll it down to where the road, I call it road blocks or shade blocks. You've got flappers, backflow preventers on that whole lateral U. That's the only way you can build it up to use it as a reservoir. It's the only way you can do it. They're there. Look. They're there.
There's a culvert, if you go down to the end of 85th Street, there's that 212 acres that's on that corner there across from the shrimp farm.
The old
That
cars.
they're pulling sod out of, right now there's cows in there. 85th Street is the last street where the tower is, where the tower is. Right down the street, all the way down the end. Just south of that, there's a culvert in lateral U, which is one of the ones that you guys opened up, which is, you go up by the guard gate, and where they park the semi trucks, there's another culvert that goes east and west that you guys opened up for 3 days and dumped water in there. That's closed, but there's that one up there, that's closed. So that backing water up from 85th Street all the way down to the marsh, all the way down to the bridge that got washed out. That's holding water. Very little of the water is trickling out because that gate is probably doesn't close all the way. Because there's probably hydraulics stuck in there.
So you're referring to the screw gate that's at, Indian now, and it's approximately 1 mile north, and you're looking 1 mile north.
Could you use the mic, please?
You're referring to the screw gate that's a little over 1 mile north of the
Bridge.
turn, the bridge, County Road 512. It sits in the youth now, and that is permanent. I don't know if it's a record here,
I don't
the district office, but permanent for being.
I'm not disputing that you had to burn it, I'm just saying that it's there, it's closed, which is, the water can't flow north from there, in other words. That's what he's saying, it's blocked up, all that water, but you go anywhere else, it builds up all south now. That's what he's saying. And then there's some pumps in there, just by where that newer plant used to be, just south of that, there's pumps in the ground, in the ditch that's going east.
You've got wells running at like ditch 28, where like the new Terra plant was. Screw gate open, wells running in that ditch, feeding lateral you overnight or in the morning, whatever you do. And then it's trickling out of where you're talking about, which is ditch 20 at the cow plants. But there's 4 of them. There's 4 of them. The new Terra plant has 2 of them. And those are both
Well, that's who gets both of us. I mean, the thing is.
Let's leave that alone.
We'll take a look at it.
Let's leave that alone, Greg, it's there, it's there. And I looked at the permits, I've spent 4 hours looking at permits, and there's only one that I see in 20 years. And it's a $400 permit for that 1,600 acre water farm. That's the only one I see there.
So getting back to
Besides,
the agenda, we're talking about the permit policies on page 39.
Yep.
And the need to reconsider some of the language based on the board's position regarding invasive exotic trees.
Can you put the mic up, please?
It's not the language, it's even basis. It's not the language.
So, since we postponed the fee thing, I'm fine postponing this as well, unless you all want to, give clear direction on the revisions you'd like to see. At this point in my review, I only found one area, that's on page 39, number 3, that I mentioned earlier, that would have to be stricken. That's the only one that seems to address the issue of invasive plants migrating into district right away.
Does a decision need to be made today on this?
No, again,
Okay.
it's not
This
time to
that definitely opens up more issues. And the landowners group is exactly right, in the sense of fairness. We're a drainage district. There's lateral U has, for all intents and purposes, a dam, has a culvert, it's holding water down. We're a drainage district. This is why the landowners get upset and they say, wait a minute, you're not paying a fee. For instance, lateral U, it's a canal, it's got to be maintained. Fellsmere Farms over there, they pay fees to maintain lateral U?
Yes.
What fees?
They pay the same rate as the Eastman properties for their 8,000 acres they use lateral U on a daily basis.
I'm looking at figures here and it does not show that. The percentages are spraying of the canals.
What we're saying is there's 8,000 acres that are east of lateral U that are paying the same rate.
What about everything else? Is Fellsmere joint ventures drawing water, using lateral U canal? At any time during the year, the minutes of the last meeting said you did. It was a special maintenance situation. It's our contention as, well, taxpayers here, they're saying, you've got to have some fairness. They're not objecting to, correct me, there's no objection to gates and whatever, holding water back so it can be used for irrigation. What I'm getting from the people, the body out here, is that they're just saying there's got to be some fairness. You're using the canal for something, why aren't you paying for spraying of all canals? Everybody else is paying for them all. I live, get serviced by lateral U. I don't mind paying for the spraying, the maintenance of park lateral, and so on and so forth. This is, I get where they're coming from. This is the reason why I'm on the board. So this is why I'm just going to ask it should be tabled, and we should discuss what it is.
Yeah, we'll definitely table it and we'll try to explain that. I mean, the water in all the district goes from the east to the west.
Correct.
That's where it's always going. So the water on the west side of lateral U is drained to the railroad canal to the west, and it gets pumped into the Fellsmere Lake. Correct. But you're saying we should be paying to pump our water.
Honestly, and there should be a greater discussion on this. If you're using lateral U for any purpose whatsoever, you got to pay. I pay for fire hydrants.
I agree. You know, but we're paying for the portion that is.
I totally agree, but what they're saying is that it's not fair. The gentleman over here, I just want to bring some fairness. We have a discussion.
We've had a discussion that, you know, it's not obvious to know how the water is moving, but we can explain it. So.
We should do a workshop, and really you should be there, Greg.
Yeah. Thank you very much.
Thank you. Can we put that in the minutes?
Be tremendous help.
you were there.
Happy to do it.
At the workshops, you would be a workshop with this board, so yeah, I hope all the board, and we got a workshop.
Well, I think it's have a meeting.
So, one question.
On to the next item.
I'm sorry.
More comments on
It
this?
says district standards. Do you have a copy of district standards? Are they posted somewhere or?
Yeah, they're on the resources page of our website.
Okay, thank you. That's all.
A little lost right now, where are we at?
We're continuing to M3, we're moving on to M4.
Resolution adopting vehicle reimbursement policy.
Just as I review files and uncover, different resolutions in the past, I uncovered this one. And it was an incentive for the employees to go on a four-wheel vehicle because of the conditions of the roads at times, particularly after rain events, which oftentimes we need to be out there and do inspections. And so in that regard, it's just reinstituting a policy that the district had back in the 90s. I don't know when it ended, I didn't go that far in research. So basically, instead of paying per mile, you just pay a flat. I think I put $300 a year, that's a per month fee. So you don't get a mile reimbursement, you just get your stipend for $300. It kind of like gives you a certainty of reimbursement, I guess, if you're going to do that recurring expense to purchase a four-wheel vehicle for work purposes. Again, that's just something I brought forward because it was something done in the past that I was a neat idea. So it's board's prerogative.
But you're saying
$3,600 a year. Is that what I'm getting at? Right. I'll sign up for that.
but your request included reimbursement for gas and fuel.
Well, that's only because that's the last one was. If you want to strike that, that's an option of the board too. I just was copying just as the last.
No, I don't think that's unreasonable. $3,600 plus gas and fuel.
Yes, the gas.
The state of Illinois goes
No
$300.
mileage. But you're right, gas receipts are.
I think that's unreasonable. I think it's unreasonable. You're using the federal rate, money, federal rate, it's 70 cents versus 48 cents. It's just, again, we're probably talking minimal, but it's not right.
So the average reimbursement has been around $300 a month. It's been less
Has
than
been
some
what?
months, more on others.
38 a month? 300. I
I
don't have a problem.
I'm sorry, I said 38.
I
Yeah,
just,
it's been around 300.
I don't have a problem with 300. You get 300 and then the federal 70 cents.
Oh, no, that's not what's being proposed. That's not what's being,
Yeah, it's either or.
it's either or.
Okay.
It's either.
Okay. But I'm just that.
But what is included is $300 per month and gas receipts for work travel, not the 70 cents per mile. That's wear and tear, maintenance, depreciation, everything. Just the gas receipt for work travel,
That's fine.
$300 per month. And that's only if the board, which is
Is that
back
just
in
for
that
your
policy.
car? Is that just for your truck or what?
It would be for both if we chose to have a four-wheel vehicle.
Crazy. You know, he's driving like 6,000 or 7,000 miles.
I have a question about that. Why, in the past, I know on the expense reports, we've seen that
Okay, don't turn it on. That's what he said.
we've been paying the equipment operator to drive about 500 miles a month, and I'm curious why that is. If there's 22 work days in a year, why are we paying a guy who's an equipment operator to drive over 20 miles a day? If one person is inspecting the ditches and figuring out where there's problems, it doesn't seem like that needs to be duplicated. Could you address that, please?
Yes, there was a history when I got here of Rob doing travel reimbursements as well. And I've been keeping an eye on those and reducing those where I think they're inappropriate. But if he does travel for work, he's due reimbursement. I don't have else to say.
Can you give us an example of traveling for work?
Today, he went out and purchased some death food for the machine. He went out and bought some new papers. He went out and bought other stuff that he needed to do.
Very good.
Seems to make better sense to have him do it than me.
Sure, but he's not doing that every month, is he?
No, well, yes, he is actually. He is buying definitely every month. He is doing trips up to the auto store, and he does inspections for me when I request to do inspections too. So yes, he's doing it all every month, yes.
500 miles a month just seems a
And
little crazy.
I don't believe he's at 500. He was at 500 a month before, but I believe he's cut down to since I've been keeping an eye on him.
Okay,
He
great.
was much higher before, I agree, and I just didn't feel some of that was
Yeah,
accurate.
it
So I
wasn't here
said,
for the
you
whole
need to
month.
be accurate. You can't make up numbers. This has got to be real.
Thank you.
His truck never leaves the shop.
Each place is delivered, so we're
Well,
going to get parts.
Obviously, that's not true because he went to the store today. So you're not there 24/7. He does leave the shop.
I ain't there, Mark. I ain't there, you know he's not driving 700 miles a month.
I didn't say he was.
Why are you going to get parts? Parts places deliver. You know, I mean, that's something you can sit there and have them brought to the office. They don't need to be driving off to get parts.
I want to point out that the policy that the district had in place since 1992, the present value of that policy would be well in excess of $400 a month plus fuel. Mark is asking for is $300 a month plus fuel. So it's not unreasonable request because we believe that the policy that's been in place is reasonable. He's not asking for
As long as it's just Mark's truck.
Pardon me?
As long as it's just Mark's truck, not two trucks.
Right.
Mr. Billy, do you have a comment? 2 trucks or 1 truck?
We got $1 million budget, guys.
If-
2 employees.
If I may make a suggestion, that it's one of the items on my card up there. Being a district manager myself, I would recommend purchasing a truck, even if it's a used one, for those errands and save it. Or make this just a lump sum stipend to not include the mileage option or the gas. Because it's going to be cleaner and you're not going to have any issues with the public picking apart the mileage that he is or she may be driving. Just a thought.
And again, I have no issues with any changes to it or not even approving it at all. It's just a thought that came up, is that it's up all in files. And getting rid of the gas, honestly, would be a little administrative, a little bit easier because I'm sitting here thinking, do I have to go fill up just before I leave and fill up again when I come back so I know how much gas I used? Otherwise, how you gonna figure it out? And so, it's no issue getting rid of the gas and just going to stuff. I still think it's 2 vehicles though, because again, during emergencies, when you need to go drive, Rob or his replacement's gonna be out there with me doing inspections.
Yeah, I'm not saying take it away, but you can use the Pepe study too and see what other municipalities and districts or managers have. It's a good background to use as well, good backup to support what you want to pass.
I say $300 per truck. Simple. No gas. Just a recommendation.
Yeah, let's check what other districts are doing. District accept, get us any information from them, see how their policy is. We need to investigate that further. It's very,
Bring it back.
yeah, all right.
Okay.
Okay, number 5, fixed compensation for work and employees.
This is a standard resolution that's been done by the district, like I see in the past. It just sets forth the, coming budget year's, compensation. And so, obviously, when it comes to the auditors, it's the auditor's contract. When it comes to the attorney's engagement letter. Beyond that, it's the, rates for the operator and then my rate. And I get no extra compensation for doing 4 or 5 different jobs. You'll notice in this resolution, I put a $27 per hour for the operator.
bookkeeping, engineering, district management, you're the secretary too.
Trying to say.
That's a lot. I mean, there's not enough hours in the day for me to be just district manager with utilities director.
Just trying to save money. There's no other reason besides that.
I gotcha. Well, I feel for you. Must be a vampire. That's all.
Do you do the website work, Mark, like the,
Yes, I have to maintain the website, build new pages when they need those.
let's get open for business, right?
If you have a contract, I can pay somebody to do it, but I'm the kind of person who's gonna try first myself before I pay somebody.
Okay, are we ready to move forward with this resolution?
So we actually talked about getting some feedback from other places. Last week we were going to be, oh, no, I'm sorry, not fixed resolution.
No, yeah, this is 11,
That's number-
number 11, fixed compensation for employees. Okay, so we have a motion to accept this resolution, number 11, here with these stated rates.
Second.
Okay, all in favor, say aye. Opposed? Motion passes. Okay, next, review of separation of duties.
I bring this up again because of my stored findings in the files. I provided some backup from some prior audit reports. Seems like every few years in the past, there's kind of Indianness on separation of duties, which there's not much you can really do when you're a one-person or a two-person shop. And that's why we have the assistant secretary, more importantly, the assistant treasurer, so that we can show some effort of oversight of me, so that we have that checks and balances in the financial system. However, what is troubling me is that statute talks about paying everything by warrant. And I don't see any language in statute. I think I provided an excerpt of statute in here. Yes, it's on the second page of the side of page 48. It doesn't seem to apply an alternative method. And so what the statute says is that every payment should be by warrant, signed by the president, and so on and so forth. And so this item talks about different ways to accomplish that, and indeed that is our requirement. With probably 75% of our invoices paid through auto pay, like FPL, like internet, just standard monthly bills, you just put on auto pay, that would be really an after the fact warrant. Once a month, I would just have all the auto pay bills listed down, signed by me, the assistant treasurer, and then ultimately the president, just put in the file. For those who are paid by hard copy check, it would be covered with a warrant, which is nothing more than a piece of paper, as you see in this backup. It's just a piece of paper you kind of put on top of all that. That is really what, you talk about cleaning up statute for 298, that's one that should be cleaned up, because that's just an infraction. The warrant method of paper things. So, what I'm recommending is that, use option 2 of my list that you find on page 47, which is provide a cover warrant for all the fixed auto pays, and then a actual warrant prior to payment for fixed check payments. Or if the attorney can find a way to say we don't do warrants at all, then I'd like to just not do them at all. But if I have to put a piece of paper on top of something, I'll put a piece of paper on top of it.
Does that issue come up with other 298s about warrants?
No, I haven't seen it, but I know that a lot of my districts are going to digital payment for a lot of things. The smaller 298s typically have a stack of checks that go in and signed by the board at the meeting, and it makes it very awkward and financial. So I think Mark's right. The auditor pointed out that we need to address this, so putting something in place is necessary. To make sure there is some oversight for electronic payments.
Could you use the mic, please, Mark?
I'm sorry, thank you for reminding me. So it's about 30,000 is the base covering cost per month for the district. That includes things that are not true auto pay, it includes paymaster, which is, for me, like auto pay, I don't do it. It's through paymaster. And a couple of them aren't auto pays, a couple are other types of methods that are automatically done. But around 30,000.
So that last sentence says, this method can be further enhanced by the use of the board of supervisors to review and sign off on each monthly bank
And
reconciliation.
that's what John Kurtz started with me, so I'd be asking that Mr. Steve, sorry,
Kurtz.
what's your last name? I'm sorry. We take over that role, he would sit with me, or he could do it at home through a PDF, just review my reconciliation, bank statements each month, making sure they're balanced, and if you have any questions about that.
Not too far to drive. That would be appreciated. Okay. Assistant treasurer is going to take care of that as a board supervisor.
Yes.
Handle that, you guys.
And I will get his email, and we'll start sharing stuff that we can share.
Thank you. So,
Motion for item 2, talking about item 2.
yes, so, I think we can look at the language and make sure there's nothing. Then number two. Yeah. Okay. So yeah, we have a motion to. Okay, motion to go forward with number 2. Okay. Second on that? Okay, all in favor, aye? Aye. Okay, so we approve choices. Number 2, on page 47, is a method for separation of duties to review financial payments. Thank you. Okay, review of City of Fellsmere water line permit conditions.
If you don't mind, I did forget to
Oh, sorry.
remind the city that this was going to be on the agenda, and I can see they're not here.
I would mind them too.
So, is it possible to move this to, I mean, our September might be a little full, so it may actually move all the way to November, but it's not kind of critical. It's been 20 years since they've done anything, so I think everything might have been a couple months.
Yeah, just so I can just give a quick.
Yeah, so basically, back in the 1990s, they got a permit to install a water line parallel to our ditch and within our ditch right of way. This is 97th Street east of Willow. And in 2015, they amended that with a new permit and extended it further all the way to the east boundary right of way and south along the east boundary of County Road 512. We imposed around the original permit time, a $1,200 per year per mile charge for linear easements. But in this case, we agreed not to charge them that linear easement in exchange for the city maintaining that ditch for us. They have never maintained that ditch. Neither do they have the machinery to do it in-house. And so this item is just to remind the board of this permit condition that was never implemented and to seek direction on how to either revise the permit or somehow hold the city accountable for their commitment. And I would be recommending that we take over the maintenance of the ditch and simply go back to collecting the $1,200 per mile per year. And some numbers that I talked about those in the area. And then obviously we have a secondary question, what should we do for the last 20 years? One option would be hire a contractor to clean the ditch and say, city, you pay that for your not doing it for 20 years, and we'll take over after that. That could be one option. Or we can do it in-house, keep time. But I think that's a conversation we should probably have with the city president. Because I don't want to get back and forth if we don't have to. But that's kind of a summary of what that is.
Okay, we'll have them present, but I like that idea of just kind of charging them to do the maintenance on these machines one time and then $1,200 a year going forward. $1,200 per mile.
And more than likely, it would be the new rate if we adopted a new policy, because that also went up. I think that's probably years that $2,000 per mile per day, so it actually might go up. And whether we charge them the new rate or the old rate, I guess can be discussed.
Okay, so we'll defer until September.
I think I'm gonna probably do that. Pretty crowded this was the item that I was asking specific direction on what our policy should be with regards to invasive exotics that are allowed to migrate on the district lands. I think we kind of talked around it all night, and at this point, just need clear direction. Do we want to make that permanent conditions? Yes or no? Do we want to make that demand? The answer is no. It's just another financial obligation we'll have to pick up, which is fine. We'll do that along with all the other things we're trying to accomplish. Some of that will be starting probably in the next month as we do some of the tree grinding that I mentioned earlier, because some of the overhanging limbs are starting to pine. So we'll be addressing, some of those issues, most urgent ones, over the next month or two, assuming our budget will stretch that far. But again, we're not taking any trees out, we're just grinding back the limbs with that. This was more of a condition to require the landowner to be involved in that. And in this item, there's also an update on other demand letters that are outstanding. The only other one that's outstanding is the Mesa Park, and I had a meeting with the code enforcement officer of the city last week, and she indicated that she has offered more time to the landowner at the landowner's request so they can work through what needs to be done to make this happen. And I remind her, and I sent her an email, that this is what the district would like. And what I would like is that Mesa Park apply for a new permit, because the permit they're operating under right now is when it was the entire Mesa Park together as one development. It's no longer that way. They're now separate parcels. And with the surf park moving through the approval process of the city, the surf park will be formally amending that master permit from the early 2000s. And when they do that, that makes that master permit null and void. So all these other properties, to be honest, have to come back in and get issued an individual permit for the systems they have on the property. Mesa Park being one of them, for a couple of reasons. One, they're violations because they removed their outfall control structure. And now they just have a direct pipe connection, no treatment at all on the property. And two, they filled in a number of dry retention areas on their property and turned them into motocross tracks for their business. So that's why they need a new permit. Even if you got rid of the whole surf park thing and destroying the master permit, the fact that they made changes, they need to come back and permit and show that their system is operating. And obviously, it's not going to operate without a control structure, but as far as the other dry retention areas, they have proved to us whether they need it. And so what I told her was that we need a new permitting issue from the district to Mesa Park Motocross.
Could you use the mic, please, Mark?
I'm so sorry. To resolve this issue. It's not as simple as just going back and putting your control structure in. You need to prove that your system operates independently and without the dry retention being filled in. And so that's the status of that. I'm okay with, not too okay, but okay for a little bit, letting it ride while the city kind of catches up. I was trying to hope the city and us could go together. But if the city's going to take too much time, then we have to decide what our next step is. And according to my understanding of our rules, our next step is to do the work ourselves and build it. And I'd really like to avoid that, because that's a lot of administrative oversight to deal with that. I will if that's our own recourse, but that's why I was hoping the city would put daily fines on them through their code enforcement action and force them to do it their way. I put the loop though. So it's really more of, do you want us to buy more time, let the city catch up, or do you want to move to the next step? That's the question for Mesa Park, and then obviously the question for the Australian fines is, do you want to be an obligation to us or landowner?
To me, that should be landowner's responsibility. I think both. I mean, well, obviously, if they fill in retention areas.
Well, yeah, that's for sure. Yeah, without a doubt, in Mesa Park is all on, clearly it's all, that's a separate issue from Australian fines. But again, if they don't act, our only recourse is to do the work ourselves and build it for it. That would require me to use one of our community engineers to do a typical development, stormwater
retaining water on the property, and now they removed that, and it's flowing freely out of it? What's the impact of them removing it, just my understanding?
They're putting, more water in our system in a quicker manner than our codes allow, and the water they are giving us is a lot greater than it should.
Right, so the change to that isn't that we go and build a new outfall structure. The change to that is we go up there and plug that outfall, right? Is that the self-help action here would be to eliminate their ability to outfall in our system until they make that correction.
But we should give the notice we're gonna do that.
Yes.
I move that we authorize Mark to send a letter to Dan that they correct that situation where we're gonna have to take action.
And again, they did have the original demand letter, so this would then, that's a copy from Pat. And so they're well past the 60 days, and so maybe it's just another courtesy letter saying, hey, you've exceeded your 60 days, on August 1st, we're going to plug your outfall, and we'll have no legal outfall anymore into our system, unless you solve the problem.
Courtesy goes a long way.
Motion by Greg, I'll second the motion.
All in favor? Aye. Okay, pass unanimously.
So back to the Australian pines.
I just want to make one comment on this. So the general law of vegetation in the state of Florida is that when you plant on your property, you generally have a right to do that, such as some cities' tree ordinances or whatnot. You as the adjacent property owner have the right to trim that vegetation along your property line up to the sky and down to the ground. So even those roots that were to invade your property, even if it were to damage that tree or to harm it, there's no right of them to do that, right? So when these trees went in, nobody cared about it. I heard one gentleman today talk about the fact that there's a bit of an equities question here, right? Since the people in the audience today didn't necessarily plant those trees, they've been there for 100 years. And, at a certain point, the districts always have the right to maintain their property, to make sure those things are trimmed, to keep them off of it. So when you look at the statute, it says if somebody intentionally or otherwise blocks your drainage district, and so that otherwise creates kind of some vague language. But it's still, generally when you think of somebody doing that, it's they're taking some action or preventing some action to be taken that would keep your district clear. So the fact that somebody has a tree planted, now it's a different story, it was planted on your right of way without your permission, and we deal with that on a lot of our canals all the time, right? People think they own all the canal and they don't, or there's a 20-foot canal maintenance easement along that bank, and they throw a bunch of trees in there, and you come along, you notice it for a year, you come along and say, I'm ripping all these palms out, and homeowners get all fired up about it, but there's no recourse, right? Because you have an easement there, you have a right to keep it clear, your maintenance activities, etc. So I say this to say that there is a bit of a balancing of the equities here. So how that's done, you have a right to maintain your district facilities. So I'm just saying that's the law. Is that as far as right to touch those things, even if you don't have anything on their property with trees, you have a right to trim along your property. Anyway, I assume this issue come up here, so that's I'm going to do a little comment for that.
So that means that we have to cut them on this, in the district, at our expense. That's right.
Under regular maintenance process, that would be a better.
Well,
Again, we gotta move forward from here. Like anybody planting them from now on, it can be taken off. But for 100 years or something like that, 5 landowners, 10 landowners later, they can't be responsible for that.
If we decide not to make landowners responsible, my approach would be to simply grind back the limbs when they become a problem and treat them like any other tree. On the far side of our banks, we want trees to grow to hold the soil and keep the bank there. So as long as they're not in the flow line or blocking through dropping of branches, I would treat it like any other tree.
So Mark, would you
Director, next item, or a couple items down. Yes, Australian pines where they block the ditch, would be part of what we'd be training about, yes.
Okay, so it would be the, you know, oats, cabbage palms, Australia,
Yes.
you're not gonna make a delineation on any of that?
No, my direction is going to be anything from the ground up to 15 feet to the far water's edge, not to the top of the bank, just to the water's edge. So that's what we're grinding, palms, oaks, whatever.
Anything that stops the spray, right? Anything that stops spray.
Correct. We'll even get, shrubby material that can't be mowed, we'll even get young juvenile palms that are growing on the wrong side of the bank, yes, we're gonna get all that as we go down.
That's what we need.
Thank you.
Okay, back on Mesa. So you're gonna set up that.
Yeah, just to resolve the next part, I think we just need to resolve the Australian plans.
Yeah, well, this is test case, say that.
How long are you gonna ask for? How long are you gonna ask for? How long are you gonna do it?
Well, generally what I like to do on code cases is that I give them a short time frame, but then I'll hold that time frame if they're working in good faith. So for example, if I were to issue the letter and next week, I'd say August 1st or something like that, it was just 2 or 3 weeks, because we've already had it 6 months. You just give 2 or 3 weeks more than notice. And if they call and say, okay, I'm going to do this by this date, I'd say, okay, then I will let you do this by this date. The first time you miss that date, you're out there plugging your ditch, plugging it out.
All right, that's fine by me with regard to the outfall, and we're seeing decide on what we're gonna do on the Australian pines, I guess. We have, if I understand what Seth's saying, I just lost my microphone. But we don't have the right to assess them for cutting trees that are within our ditch.
Thank you.
Yeah.
So we're going to let the Australian pines go, and I'll be dealing with that as part of my maintenance routine.
Thank you.
Gonna be a-
I think so, regrettably, I don't have another answer. So, okay.
Gonna be expensive.
And how many miles we got to do? A lot of miles.
I'm ready for the next item.
Okay, let's move on to, draft budget. Page 62.
And again, this is really just discussion, there's no action, and really don't need to be discussed. I just basically wanted to try one more time to go back and sharpen the pencil one more time to see how low I can get the assessment before our September adoption. And obviously, it somewhat relates to the state park, which will be discussed in a few minutes. But I don't believe there's much more I can squeeze out of this thing. It's pretty squeezed.
What page are you on?
On page 62. And so if we were to go forward with this version come September, and depending upon the state park resolution, the assessment would be either 3934, unless the state park is not included, then it would be 4384.
So we're changing that from the 4505.
Well, if you recall, the 4505 was just a maximum. We knew we were going to be different, this was just an effort to try to see what that difference is.
Hey, Mark.
Yes.
In this budget, you talked about the money that was coming from park lateral not being completed. Is that the same, this is the same budget, correct?
No, this is next year's budget.
Next year's, okay.
Yes, no, that particular issue was in the amendment to this year's budget.
Okay, can I speak about that just a minute? I made a note, I just have a question. Or do you want me to wait until the end?
Whatever you choose, board president correct?
Gophers.
Yes, and part of that money is being returned to finish that job.
Returned,
Returned to the park level project. Maybe not the same contractor, but it's basically being returned. The only thing that was left to be done was restoring the bank.
okay.
So we're gonna go, probably a lot of bulldozer work, just bulldozing the piles of debris that have been left and other things like that. Maybe some mulching if something needs mulched, but we're gonna end up with a 25-foot drivable maintenance and inspection path immediately along the top of Bank Park Avenue. Outside that 25 feet, because as you know, there's more than 25 feet in many areas, we're not gonna touch it.
Okay, I was just alarmed thinking, okay, we're using that money to help the budget, but then I'm thinking, what happens when we need it? Okay, that was my question.
What is the mandate on the turtles, Mark? When can we resume that?
Well, it depends on who you ask. If you ask the inspector lady, and my environmental consultant was 18 months. But if you read statute, as I read it, they should never stop the project because we are a utility. We are a stormwater utility, a linear utility, and there are exemptions in Florida statutes for linear utilities.
So when's the 18 months or?
I have to go back and look.
Okay, I'll get with you later. I just wonder how long we need to resume that.
So I have nothing really to add on this. It's really just more information you can digest and the public to see.
Okay.
What is the update on the state park?
That's on the agenda. We'll get to that on the agenda.
Right now on the contract, should we move overhanging fence, page 66?
Yes, now this one, is a contract that, again, is not
64, page 64, right? It's final budget.
no, we're past that now.
And I had a thing, I just wanted to be clear that we're not trying to create a south unit, which was my question for Greg.
I'm sorry, I'm all right.
Yeah, I did have it.
Thank you.
Sorry about getting that.
No, the budget does not include the creation of the south unit. It includes the full assessment on the south unit. What I was calling the south unit, which is basically all land south of 77.
But we shouldn't be calling it a south unit because it's not been created. It should be the east, it should be the east unit, not the east, not south unit.
Yes, that is ultimately how it's going to end up. I do it this way, in case things change in the process, I don't have to redo my spreadsheet. But you're right, it's going to end up
It
that way.
shouldn't be listed as south. It's still the east.
Yes, I don't think we should be dividing that any way, shape, or form between the east and
South
west.
should come out of that completely.
Well, again, for the purposes of the budget, the only two pages go in the budget are the first two pages. These other pages are supported with documentation, and so they're not really part of the budget.
We just want to make sure we're not creating another unit, like segregating another unit of property.
They are part of the budget because we're voting on them, and it's paperwork in the packet.
No, we're only attaching the first two pages to the budget resolution
Why is it in the packet?
for transparency.
Okay, thank you. I'm against the dividing of the south.
And there is no division currently with this budget.
So we're just saying there is no south unit.
That is correct. So back to the overhanging limbs. So this will be a contract under 35,000 with the bid threshold, so I'll be executing the contract on behalf of the board. We're working with the district attorney's office to get the final contract document itself. And I have met with probably no less than 7 different vendors. We've driven around and looked at our overhanging limb problem and the other problems we have related to vegetation. And I'm going to address 2 of them prior to September 30th. One is the park lateral maintenance strip. That would be $200 an hour bulldozer work. The other is going to be mechanical grinding of the overhanging limbs. And most of the machine rates are $250 an hour for those machine rates. Talking with some of the core group citizens, we're going to implement in the contract a 1-week test to understand the efficiencies and the productivity before we decide to spend the full amount. In case we're unhappy with with other local governments. And so one of them, Brown and Sons, they work with Inter County, another one works with Palm Bay. So again, they have local experience and people to talk to, and they all come with great references. We are going to decide which to use, to be honest. That's another reason to just start small and see how it goes from there.
Mark, is this going to occur on all the sublaterals?
No.
The,
It's only going to occur on sublaterals that have a heavy
that's what I meant.
extent of overhanging limbs.
Okay.
And what you will see on future maintenance maps, the inspection map, the colorful map that you all will create, you'll start seeing percentage numbers in small places. Those percentage numbers represent the percent of the ditch that has overhanging limb problems. There's some that are 0, some that are 5%, some that are 50%. And so obviously I'm going to hit the 50% first, knock those out, and work our way down. We probably won't get to all of the ditches with the 35 we have in the budget. I don't expect it will, but we'll hopefully make a good dent. And so this particular item, it's somewhat of an information item because it's all actually in the contract. Don't bring the board action, but it's really just let you know where we're at, where we're going. I hope to have the tree contract issued hopefully by mid-July and be done by mid-August, and then roll right into mowing late August, and then right into spring or September.
But you're committing to a 3-year contract?
On the tree limb, yes, I figured we might as well. I mean, again, with the caveat that we can always cancel. We always have the ability to cancel with or without clause. So that's all we're going to be doing. We're also going to have a 1-week test or whatever you want to call it. That will give us an opportunity at that point to say, okay, let's look at your work. What we did, it's time to submit. And during that week, I'll have a lot more hands-on inspection oversight with them, once we pass the first vetting process.
So is that $250 an hour for the machine hour, or is it $250 an hour for the time on the job?
Can you bring up the microphone?
Yeah.
Question. So my question to Mark was, is that $250 an hour for the machine hour, or $250 an hour for the time on the job?
Time is on the job. If he has 2 machines, he's going to get paid for each machine. But he's not getting paid for a machine and operator.
So I'm trying to reason with this contract we're doing, he's going from place to place, he found us that we're going to pay him $250 an hour from site to site.
Yeah. In a sense, it's no different than us paying our operator to go from site to site. And it's part of the normalization of a distracted and linear system.
And do I understand you want a couple contractors to start?
Well, I'm thinking of doing one for park lateral and then one for the overhanging limbs. I just can't break 35,000 times. It's not enough to make anybody interested. Like, say I get $18,000 contract there, they got other things to do. And by promising a 3-year, if they pass this first week test and they come through fine, it guarantees them more work. For these contractors, $35,000 is small for these people. These contracts are small for these people. These people are working these restaurant projects. Any thoughts on the process? Any changes you'd like to see?
We'll have a move too far.
Expensive. And we'll be able to help if needed, if we can help monitor, watch, anything.
Okay, I guess we get the Hawks, we'll be looking, and, yeah, it's experimental, I mean, it sounds okay on the face of it, but we're gonna find out. I think it's great. So with trepidation, we're gonna have a motion to approve the, contract to remove overhanging limb for
It's a contract.
It's not a contract,
It's
it's
the
just
concept of the project.
it's approval of you to go forward to engage the contract on that basis. So we have a
got to dive into with the district for the benefit of our new board member and those who might not know. This goes back to an agreement, it was a purchase agreement between Fellsmere and St. John's. St. John's had acquired the property where the park exists, but we still own the ditches that were in there, and we still assess the land. At that time, we had made the agreement to sell the canals to the water management district. And as part of the agreement of that sale, they were to do two things. They were to develop a plan that was going to show that they were going to take whatever steps necessary to reduce their outfall to the district by 10%, which seems like a pretty low threshold to me, but that's I didn't draft it. They had 6 years to make that plan and put that in place, have that plan be approved. And if they weren't able to accomplish that, to make a payment to the district in the amount of $20,000 a year until such time as they could make it. What occurred was they gave us a plan apparently at the 11th hour of those 6 years. There was some comments made by the district engineer. They resubmitted, there was some more comments. And then they wanted the district threw up its hands and said, we've done all we can do here, and went away. I love that notion because if I ever submitted a permit to them and got 2 REI letters for additional information, and I said, I guess I don't need this permit after all, doesn't really seem like how the process works. Nevertheless, it appears that at that point, no further discussion was had. They made no effort to implement the plan that they put in place, which was simply to plug a series of ditches along the central spine road, and their statement showed that that would provide the necessary reduction. Nevertheless, they didn't do the work, and also they never began paying the annual assessment. It was not clear when I first read the agreement that that month annual payment was to be in lieu of the assessments, because that agreement didn't really make that clear. I went back and I reviewed the minutes from that period, and it was clear from the discussions the board had and others in the audience that that was in fact meant to be a payment in lieu of assessments. Not really memorialized correctly, but that's the way those discussions went. So with all of that background said, we scheduled a meeting, and the chair and I met on June 19th with both the executive director of the Water Management District, Mr. Mike Register, and his general counsel, Aaron Preston. As a fun little shot across the bow, before we got there, they provided us notice that they had filed a lawsuit that said, we noticed that you have not put a budget with an assessment against us. We contest that we don't have to pay that. And Karen gave me a call, and they were about to do it, and she said, look, we're filing this because we believe we have to from a timing standpoint to make sure that we had our lawsuit in the queue, but we're going to immediately abate it. We're not intending to pursue that litigation. We're putting it as a timekeeper, a shot across the bow, but we're not saying that we're not here to continue to work and gain good faith with you to resolve this amicably between the parties, because nobody wants litigation, and as a general rule of life, I agree. So we had a meeting with them. I personally believe that they are obligated to pay assessments under a law. There was a court ruling that came out against South Florida several years back. It was called Hope South Conservancy District ruling, and that ruling said that both they and the county in that instance were required to pay assessments to Hope South Conservancy District. I asked Erin if she thought that case applied. She gave me some kind of slightly wishy-washy answer that I don't necessarily think will today. But nevertheless, their case raised all sorts of procedural issues. So they continue to hold the stance that if we were then to apply the straight assessment, they will contest that in court. With that said, I brought it back to the local agreement. I said this agreement had to be paying an annual fee. You have to be paying it for several years. You have made the statement that you've done what you had to do, but you didn't, because we didn't do the work that you proposed doing, and never moved forward with it. And until the time as you've shown that you've done that work or met that standard, you need to be paying this. So those are the discussions we've had. They agree that they need to come back and either figure out whether they met the standard or what they do so. There's a whole side issue. We've not gotten a response from them. So at this point, we're still somewhat waiting. Obviously, we hope to have an answer from them prior to September when it comes time to adopt the budget. So that's the full story of where we're at with them. Then when we come back in September, the board will make that decision whether we want to pursue assessments and then move through the litigation costs to defend it. Hopefully, they come back with some agreement to pay the agreed upon fee in lieu, which I think would be the proper and best outcome of this. It's not everything the district should be getting from them, but it is the agreed amount. I suggest that they pay the last 20 years that they owed us, and if they want to cut us a check for $400,000, we'd love to see it. And it's going to go anywhere. So that's the update as to where we're at today. We have sent me 2 follow-up emails since that meeting on the 19th saying that we haven't forgotten about you. We are reviewing this internally, running it through the giant bureaucratic machine that is the St. John's Water Management District. So that's my update. I can answer any questions you have.
And one, are they in favor of a direct bill versus an assessment?
I'm sorry, say that again?
Are they in favor of a direct bill versus an assessment? That's just a language.
I'm hoping they'll be in favor of the fee in lieu that was agreed to.
The situation is a little more complicated by the fact that St. John's owns a percentage of the land and the Department of Environmental Protection owns in there. So trying to get the 2 agencies to come into a common agreement or viewpoint makes it that much more complicated here. So I think balls in their court right now. We're waiting to hear from them. We can
So,
sure use
do
one.
we have a lawsuit now against us?
Yes.
They have filed a notice letter and put it immediately in abeyance, so there's nothing occurring with it. You're not spending any time for people to go out and start answering their pleadings or any of that.
I think it's a pretty safe assumption that they're prepared to litigate
Fine.
if we go for the full assessment. And, they have in-house counsel, so it doesn't really, well, we're paying for that counsel. That's taxpayers to St. John's. But, yeah, I would say that their attitude is, they're not gonna roll over on the
Yeah, we
assessment.
should have never sold them our right away, the bottom line. That's obvious.
I'd like to actually see a statutory change that honors that ruling in Hostown that says that residuals can be circulated. Obviously, once this ruling came down, it's bad news for them, but it's not like they were all going to run out and out on the board with electric 98s and say, hey, can you start betting guys a check? So the onus has fallen on districts to put the assessment in place and then litigate if they want to. I want to find my district to take that litigation, but Hostown Conservancy did it and won, and it should be easy to make that request. And go, yeah, you're right. This all really looks like makes it a little more complicated in this instance. But, under that rule is good law. And these districts should be paying their 298 charges. If they're in the district and getting stormwater benefits.
So what is the next step for us, and you've got timeline on A stuff?
The timeline for us is when we're going to adopt that budget. So there'll be a recommendation based on what they come back with at this point.
Ready for public comments, Mr. President?
Yes.
I have, John Savage.
Again, Mr. Nelson, don't take this personal. I have a question, first, the East Direct bill, how do we end up with that? Because I see that it went from Fellsmere Drainage District to you, or not you, but, let's say whoever Fellsmere East LLC is, because I always thought that Jack Berry Groves was the East Direct bill, and now I find out there's 2,000 acres to the east of that is actually the Fellsmere East LLC, and then there's Bernard Egan, which is the old Jack Berry Groves, but I think it was all one property at one time. How did we get to that being a direct bill, and how did it go from the 2,000 acres east from Fellsmere Water Control to, I believe that, I don't know that you own it, but it's one of the LLCs that you and Tim Dooley and Richard Carnell set on.
So the word, just for the,
Direct bill?
yeah, explain the part, that Jack Berry Grove was 4,000 acres. Okay? And, I want to say around 97 is when the district purchased the 2,000 acres from Jack Berry Grove, the east 2,000 acres. They purchased that with the purpose of building a reservoir there. That's what the district.
St. John's.
Excuse me, St. John's purchased it from Jack Berry.
Right, St. John's, okay.
Yeah, big St. John's purchased that. And we, at St. Berry, wanted to sell the whole 4,000. A couple years later, yeah, 2002, I want to say we bought the 2,000 acres to the west of that. Then the district came to us in 2005, 2006, and they said that 2,000 acres on the east side was not a good location to build a reservoir because it was too sandy and it wasn't going to hold water. It was going to be difficult to work. So they asked if we would consider selling that land on the west side of Fellsmere Farms and take part cash and part swap.
That was the headwaters, 2,000 acres of land.
Yes, that ended up being part of the 10,000 acre headwaters project. So that's, we got that back from the district in 2007 or 8 as part of that swap.
Why is it a direct bill? What is that?
So as soon as and it's the same with the situation with St. John's on at the state park. As soon as the state government owns the land, it's the policy of the property appraiser to take that land off the tax roll because they don't pay property taxes. So that land came off the tax roll when we reacquired it in 2007, 2008. It's always just been off, and that's the way the property appraiser has handled that. So,
But it's no longer like a government-owned piece of property. Why is it not being assessed the same way as the rest of the district? Is what kind of what I'm asking.
It has the same assessment. The only thing it doesn't have is the 6% surcharge, which everybody in this room doesn't have to pay if they pay their invoice at the very beginning of the meeting.
When you look at the history or whatever it is you look at, it shows 0 for assessment. I'm sure you're paying the assessment.
yes.
I was just wondering why is it still treated as like government land being direct billed instead of like in the rest of the district?
Well, I guess the net effect of it would be we pay 6% to the property appraiser that we don't need to do that. Yeah.
Yeah, no, I just wonder how you have the ability to do that, not being a government entity.
It's just the property appraisers just always treated that, since it came off, they just never put it on. So,
I want to take, I've taken a lot of your time, I want to thank you because this board has definitely sat here and listened to everybody here. And I want to thank Tim, Mark, Greg, especially Greg and Mark. I want to thank y'all because y'all kind of took a beating here, but at the same time, we're way more educated. And I have 2 just little simple questions. And understand that y'all got rid of to St. John's, but the east part, which it looks like one sliver comes from St. John's, which covers Main Canal, and then there's another sliver that runs right into the boat ramp. How did y'all come to acquire that? It's like $100, I think it's $100 quick claim deed, and the property ID number is 12520, and it's like 25 or 29 acres. I'm just wondering why do y'all own, FJB own portions of the drainage, the main drainage, is what I'm asking, I guess.
So St. John's, again, big St. John's, I say big St. John's because we have another district in New County called St. John's Water Control District, but St. John's River Water Management District, as part of the Headwaters project, they purchased that, the Fellsmere main canal. They said they needed to own that, and that was just how they were designing the plumbing on that. So they purchased the property from the Fellsmere Control District.
Water control?
And so that was part of that transaction in 2007. They purchased property from us, they purchased property from the Water Control District. 10 years later, they came to the conclusion that they didn't really need to own that property, and so that they wanted some, I'm trying to remember, I think they wanted some other property of ours that they didn't need. And so there was a transaction there where, again, there was some land swap and some cash changing hands. But what had happened is, my recollection is that the district, St. John's, said they wanted all of the main canal, but when their when their surveyor drew up the legal description, they decided they considered the berm to be a liability. It has all the dirt on it. They thought it was a liability. I'm not sure why, but that had something to do with they thought people would be going up there and possibly getting hurt or something like that. So I think unbeknownst to Fellsmere Water Control District, when they drew up the legal description, they left that out of the legal description. So it came as a surprise later to see that St. John's hadn't actually acquired that. So it got real complicated at that point when they were doing the transfer back.
It just seemed like it being like our main drainage, that it would have been back to Fellsmere Water Control instead of FJB.
So in the meantime, St. John's River Water Management District had put a plug at the east end of that. So it's just a full plug. That water cannot go east at all.
Now that's at the elephant farm?
Yeah, you're right.
Is that mile or S? I'm just so I know. That mile
that's railroad. There, but the plug is a little bit east of there. My recollection is a little bit east of that. So St. John's had done that because they wanted, because that was supposed to be part of Headwaters Lake. So they just put a permanent plug there. And
what is it? So the canal is the railroad canal at the elephant farm? That's where all your property drains?
the railroad canal drains to the north into the old Fellsmere main canal and then goes west into Headwaters Lake.
But the sub-laterals are S laterals, right? Sub-lateral S?
Yes. We call them laterals. There's lateral S.
All your
That
sub-laterals,
is actually to the west of that.
all of your sub-laterals drain to what canal on the west?
Well, the sublaterals are always drained to the west, but the ones there will drain from the property west of U Canal drains to the railroad.
So it's the railroad.
The railroad canal, and then that water gets pumped out into Headwaters.
Okay, that's what I was wondering. So S is even further towards Headwaters?
Yes.
Okay. Thank you.
Next on the list is Christine Hall.
You answered the
Done.
question.
Last one is Jeff Gardner. Yes. I have no more speakers.
Okay, we're adjourned. Thank you.
Thank you, guys.